Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to answer the question, how much notice does a landlord have to give a tenant to move out prior to filing an eviction proceeding? So if there is a lease in place with a specified termination date, the landlord doesn't have the right to terminate the lease early unless the tenant violates the lease or fails to pay rent, and we'll talk about those situations in a moment. If there is no lease, or if the lease does not specify a move-out date, or if the lease is expired but the landlord has continued to accept rent, turning it into a month-to-month lease, the landlord generally has to give 30 days notice to a tenant prior to having them move out. And if there's no lease, then the landlord can ask them to move out for any reason that's non-discriminatory. So the notice has to be in writing and has to arrive to the tenant at least 30 days prior to the move-out date. It also has to include the specific move-out date. So again, the general rule is in the absence of violation of the lease or non-payment of rent, if the landlord wants to have a tenant move out, they're required to give 30 days notice before they can file an eviction proceeding. The landlord can give less than 30 days notice before filing an eviction proceeding in a couple different situations. One is the non-payment of rent. So if the tenant fails to pay rent on time, the landlord can give them a 5-day notice to either pay rent or vacate the premises. If they fail to pay rent within those 5 days, the landlord can file an eviction proceeding. The second situation is if the tenant violates the lease. In this situation, if the tenant violates one of the terms of the lease, other than non-payment of rent, which would trigger 5-day notice, the tenant's entitled to receive a 10-day notice to either fix whatever needs to be fixed with their violation of the lease or leave the premises. That's called curing the violation. So an example is if the tenant brings a pet onto the premises or is living with a pet, when the lease says no pets are allowed, the tenant will have 10 days to no longer have the pet on the premises and fix the problem, or to leave the premises before the landlord can file an eviction proceeding. Finally, a holdover tenant is one that overstays the term of the lease. And if the tenant holds over past the termination date on a written lease, an eviction proceeding can be initiated with no notice to the tenant. Now, there's an exception if the tenant pays rent after the written lease is expired and then the landlord accepts that rent. Then this turns into a month-to-month lease and a 30-day notice is required. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you'd subscribe to us on YouTube, SoundCloud, Apple Podcasts, or wherever you listen to your podcasts or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.